Hi, everyone. Thank you, Yoshibel. Thank you for attending this webinar. The purpose of the webinar is to talk about the checklist for restructuring in France. So if you turn to the next slide, well, you will see our beautiful faces, of course. Then we'll turn to the slide after this one. My colleague here is Stéphanie Poussou. She's a senior associate at Capstan. I myself, I'm a counsel at Capstan. We are both based in the Paris office, and we both do quite frequently restructuring for our most of the time our foreign clients who have French subsidiaries. So we're used to explaining the French concept to foreign clients. So the purpose of this webinar will be to talk about, after a short introduction, if you can turn to the next slide yeah, thank you very much. So after a short introduction, we'll be speaking first of all about restructuring in the sense of post redundancy. So first, the timeline of the restructuring project, the document that you need to prepare, and also the recent focus of attention. So this is very important because the expectations have changed over the past few years. We'll get to that after that. Then point 5 will be about the other tools that you may want to consider instead of a forced redundancy plan. These are the tools that need to be considered before launching the project to make sure you're going in the right direction. And then we'll be happy to take any and all of your questions so that we can make this as interactive as possible. There will be one slide where we'll be asking you a question and then you can answer via the chat, and we'll see whether you're following our webinar. So if I may introduce, before I let Stephanie move on with the slide, if I may introduce this webinar. 10 years ago, in 2013, in June of 2013, the law regarding restructuring has changed. We had a lot of litigation during the consultation process. And the law changed that instead of having all this litigation during the consultation process and us being unable to tell you how long the consultation process will last, the law changed so that there is a certain timeline, and the consultation is going to last a certain timeline. We'll see that with a timeline after. And then the Labor Administration has to approve your plan. This moves the litigation from the consultation phase to the after consultation phase. And actually, the Labor Administration has been under a lot of pressure to check this and this and that, and their expectation went higher and higher. And plans that we used to do, let's say 5 years ago, now will no longer pass the administration approval process because their expectations are higher, because their decision to approve or not to approve the restructuring plans are challengeable before the court. And these challenges are more and more complex, and this led to, well, a few plans being cancelled by the court, which is of course difficult to tackle with when it happens. And so the expectations are higher, which means that we need to adapt. And that's the purpose of this seminar, to tell you how to adapt to this new landscape and these new expectations. If I may move now to the next slide, which is about the timeline of the restructuring process. So this might be just a reminder for most of you who are used to France, but we'll be explaining in a few sentences the timeline for the restructuring project. That will be the next slide. The first step, thank you. The first step would be to prepare, of course, for the restructuring. There are a number of things you need to prepare. We'll be, of course, tackling with that during this webinar. This is a phase that needs not to be neglected. It's better to have a good start, even if it takes 2 weeks longer, than to have a rough start and then having difficulties managing expectations, managing challenges from unions, from the Works Council, from the Labor Administration. You will be under a lot of scrutiny during the consultation phase. You will also be you'll be taking a lot of time in meetings, discussing with the expert, negotiations, consultation, etc., which means there will not be as much time as you would like to be able to think this through and to take the time you need to build on your strategy. So the preparation phase is absolutely key. You don't have two chances of making the first impression. In the slide, we put 2 months. That's, of course, the ideal situation. We know for a fact that actually we rarely get 2 months, and we adapt. Of course, what will be the most challenging will be retrieving the information, gathering the information from your stakeholders, internal stakeholders. That is the most difficult part of the process, most likely. Then you will have the meeting zero of the Works Council. Meeting zero, we call it meeting zero because it's not the start of the consultation process. It's just the meeting during which you provide the information, the package to employee reps, and then you explain, of course, the content of the project instead of just sending it by email. Of course, it's not really appropriate. So that's meeting zero. Then meeting one will be the start of the consultation process, which will last between 2 and 4 months, depending on how many redundancies are envisaged. That's the consultation process per se. During the process, you'll be consulting with the Works Council. At the same time, you will be handling negotiations with unions when you have unions in the company on accompanying measures. That's very important. We'll be telling you why in a few moments. And then you will have also discussions with experts. We don't really see plans where experts are actually not involved. Most of the time, experts are in the process. They advise. Employee reps will be discussing that in a few slides as well. Then you have the opinion of the Works Council, or if they fail to provide the opinion, then that's the end of the time frame, and then you can move on.
Just maybe one thing, it's a non-binding opinion, so if they consider that they do not agree with the economic rationale or all the thing, it's not something that will block you for the rest of the, you will be able to implement the procedure.
Yeah. And then once you have the opinion, you will go to the Labor Administration. Their name change every few years, and now they're called REITs. But it's the same thing as a Labor Administration. It's not the Labor Inspector, it's a different body. And they're supposed to have 15 days or 3 weeks to approve the plan, depending on whether it's an agreed plan or a unilateral plan from the management. But as we can see from our practice, actually they take more time because the 15 days, 21 days deadline will only start from the day the file is complete, and they have to check that first, and they take a few days / weeks.
More weeks,
yes, to check whether it's complete so that they can gain time, because they have a lot of plans going on, so they want to move as much as possible the deadline. So we put 1 month in the slide. Maybe it's a bit more.
Usually it's for 1.5 months and even 2 months. Maybe one thing regarding the labor administration, we put it at the end of the slide, but during all the process, if you want to have your green light at the end, you need to talk and you need to be proactive and to talk to labor administration during all the process. You will see that you have a web portal on which you will upload all the documents. We will see which documents after. And during all the process, we highly recommend that you try to reach the labor administration to discuss with them in order to avoid, bad news at the end, because they could consider that some accompanying measures are not sufficient or something like this. It's very important to be proactive. Sometimes because they have a lot of work, they will not answer, but try if you can to create a relationship with them, and it will be a good point for you in the end.
Yeah.
And maybe what we can add also, can you go on the slide before? We have this 1 month approval phase. Please note that because you have your opinion, it does not mean that you cannot do anything. That's not the case, because you already consulted the Works Council on the reorganization you want to implement, and therefore you can do something. So you can, for example, create some position. It was something provided in book 2. You can also implement the internal redeployment phase to move the people in the group. What you cannot do is terminating the contract, redundancies.
And actually, it's been said by a very recent decision of the highest court. So we've had challenges from labor administration in the past regarding this. They disagreed with what Stéphanie just said. And actually, the highest court just took our position, which was just explained. So if you're having difficulties in this process, then don't hesitate to send us an email. We'll be happy to share with you the content of that recent decision so that it can close the debate. And you can indeed start your implementation phase, which is the next slide. The only thing you cannot do, as Stéphanie just said, is make people redundant. So that's an indicative time frame, an indicative timeline of an implementation phase. Of course, if you're having a voluntary departure part, of course, the phase will change because you will have to include a voluntary departure phase. But this is a forced redundancy typical timeline. So the first step would be to apply the social selection criteria. Most of the time, you will need, well, actually all the time, you will need to ask information to employees. How many kids do you have? Are you a single parent, etc., etc.? Do you have a disability? So that will take a bit of time. And you can do that during the approval phase by the labor authority. Then you will have the internal redeployment phase. The scope is the group in France. The legal scope is a group in France. Then you will make the employees redundant. And then once you've provided them with a termination letter, the situation will be different depending on the size of your group. If you are a group, well, a company belonging to a group of less than 1,000 employees across Europe, across the European Union and the economic area, the economic European area. In this case, you will be under a scheme called the CSP. The CSP is an enhanced unemployment insurance benefit scheme. It's actually they all almost get 100% of their net salary during 1 year for employees who have more than 1 year length of service. The only thing they need to do is they have a choice of accepting or refusing. The employees have a choice. They have to renounce their notice period. So notice period is paid by the employer to the scheme directly. They don't get their notice at all. So it's not an extra cost for the company. It's the same cost, just two different modalities. And also the employees are off payroll 21 days after the proposal of the CSP has been made. So in a nutshell, you propose a CSP, you tell them we're making you redundant. They have 21 days to accept. If they do accept, which will be the case for most employees who have more than 1 year length of service, most of the time they will accept. Then 21 days after that, they are off payroll. Then second hypothesis, you are a big group, more than 1,000 employees across Europe, and you have to offer at your cost the redeployment leave, which is going to be 4 to 12 months, sometimes more for larger groups. That's including the notice, and they are paid, of course, the regular salary during the notice, and after that they are paid 65% at the minimum of the latest salary, with a minimum of 85% of the minimum wage. This means that these employees remain on payroll during these 4 to 12 months, possibly more. And the labor administration will actually be very, very careful on the length of the redeployment leave, because the longer it is, the better it is for the unemployment insurance scheme, of course. They are assisted by an outplacement agency. And you can see that if you are on the lowest side of the redeployment leave, let's say you offer the minimum, which is 4 months at 65%, which is going to be a challenge to be able to do so with a labor authority. But let's say you do that, then the employees will tell you, well, I'm better off with a CSP. So you have to bear in mind that the CSP will be a point of comparison for employees. And if you offer less, then of course you will get noise from the employees and from the labor authorities as well.
We can go to the next slide, please. So now we are going to focus on the preparation phase. So Fadi explained it was approx 2 months. And we will see in the next slide which are the documents we need to prepare. So the first one is called Book 1. So that's the document in which you will find several information, and you will have first at the beginning a summary of the economic grounds of the Book 2. I will explain what is Book 2 after. So you have first a quick summary. Then you will have the calendar for the information and consultation procedure of your workers. You will also have, if you have unions within your company, you will also have the meeting of negotiation. Then you will have the number of positions you are contemplated to eliminate. Maybe you will offer some modification of employment contracts, and you will find we will find also the information in this part. And then what we will find the timeline of redundancies. So we will explain. We do not need very specific dates, but we need to have, for example, a Q1 2023. We need to have some dates. And after, we will have all the accompanying measures that will be offered by the company for the employees. So we will find in this accompanying measure what is offered in terms of internal redeployment. So before, you cannot dismiss or make redundant an employee like this. You must before try to find an internal redeployment position within the group. So the legislation has changed in France a few years ago, and now you have to focus on France. So if your company belongs to a group and you have some companies, other companies located in France, you have first to check if there are available positions for your employee, and you have to support his mobility within the group. And if you fail, then you have all the accompanying measures that will be offered to this employee after he's made redundant. So you have the redeployment leave we discussed just before, and for example, you will have support for training costs. You will have support for his moving in another department, things like this. So what you will find in the Book 1. In most of the companies, if you have unions, you will prepare 2 versions of this Book 1. You will have one which is unilateral, that the management will decide which are the accompanying measures he will offer. And in the second one, it's an in-house collective agreement. The purpose of this document is to be negotiated with your unions. When we start the procedure, our recommendation is to have better accompanying measure with a higher cost in the in-house collective agreement in order to try to obtain the signature of the unions. So you have these 2 documents to prepare, and it's very important to reach an agreement because the control of the labor administration at the end of the procedure will not be the same. If you reach an agreement, which is what we really try to obtain, it will be a high-level control, we could say, and it's only 15 days, as from the date your file is completed. And if you do not reach this agreement, then it will be a very strict control, and they do not check the same thing at all. So it's very important, try to find an agreement, to reach an agreement with your unions.
And actually, what they do check if you are on the unilateral route is whether the accompanying measures you're offering are consistent with the resources of the group. So we often get the question, what is the legal minimum for a collective redundancy in France? And actually the legal minimum will vary depending on the resources of your group. So that's also why it's better to have an agreement to avoid that debate.
So the second very important document is Book 2. What is Book 2? It's the economic notes in which you will explain, you will detail your economic grounds. What's your reorganization? What do you want to do tomorrow after the implementation of this reorganization? Regarding the economic grounds, it's something that is provided by the French Labour Code, so we cannot, we do not have any
any control on the content?
Well, yeah, we do not have any control on the content. So we have the economic difficulties. So it's high. We have an issue with the turnover of less orders, this kind of thing. You have also the need to reorganize the company to safeguard its competitiveness. So that's one of the grounds we usually use and recommend for our clients. So you have these economic grounds you need to explain. One thing maybe to have in mind is that if the economic grounds you have are not 100% consistent with what requests the French Labour Code, it's not an issue. You will be able to implement your reorganization. The only thing is that at a later stage, when you will have your employee made redundant, you have a risk that they decide to challenge these grounds before the French Labour Codes. But you will be able to implement your reorganization that the Labour Administration will not check the grounds you included in your Book 2. So that's the first thing. And that what you will have in your Book 2 is how many positions you have at the beginning of the reorganization, how many positions you will have at the end, and how the company contemplates to work after the implementation of the reorganization. So you have to explain the interaction between the teams, between management. All these things must be clearly explained in these documents. You have, or it's more or less a new obligation, but now we have to include in this document all the environmental impact of this project, and that's something that will be checked now by the Labour Administration. And we have a third document, so we highly recommend to prepare a third document. Legally speaking, it was not one, but that's what is now requesting what is requested by the Labour Administration. We have to prepare a document which concerns the health and safety conditions. And in these documents, you will have to explain what about the workload, what about the employee stress, and what will the company implement, to mitigate all these risks you have identified when preparing your restructuring plan. Maybe one red flag, and it's more about practice, but in the last restructuring plan, we had to prepare with our clients. The Labour Administration told us, you do not talk about HR people, but they are the ones who are, involved in the preparation and everything. And you need to think about specific measures for this population, because the Labour Administration is very attentive on this specific person.
Yeah, we have one question from Sergio. Can the employer offer a suitable alternative role to an employee in a different city in France? And if so, would they have to fund the employee relocation? So the answer is yes. The scope is France. And do you have to fund employee relocation? The answer is also yes. In practice, it's highly recommended to include this in your plan. If you don't, you will get the questions on the Labour Authority. Now, in practice, what we can see is that the number of people who agree to relocation is quite small and redundancy plans. So it's basically, quite well, not free, but almost to include that kind of measures, because we know that the number of people who will be doing it will be small, and you can put, a lot of 000 amounts, but in fact, the budget is going to be used maybe 5% or 10% or even less. So, but yes, you do have to fund employer allocation in these circumstances. We have another question from Yusuf. Are employees that are on congé de reclassement eligible for new incentives that are implemented by the company, although the employees are on garden leave? That is a very good question, actually. A question we get quite often. I guess it will depend on the incentives. For instance, they are eligible to the canteen. They are eligible to the social and cultural activities of the Works Council. Now, if you're talking about a general raise of wages, then no, they are not eligible.
But for example, one thing to have in mind is that when they are under redeployment leave, they should be, they should receive a mandatory profit sharing scheme or this scheme until the end of their contract, until they are off payroll. They should be entitled to all these schemes. And there we have one question, I think, on each plan. It's about the company car. Most of the time, so at this stage, we do not have any, case law regarding this point. And what we recommend to our clients is to provide in the book one that they will have to give their company car to the company after the first part of the redeployment leave, after the notice period, because during the notice period they can keep their car, but after they have to give it back, to return it to the company. But if it's not, then we have something in place that we can, on payslips, we can do in order to let them the company car. But it's a very good question, because it's one of the questions we have on in all plans.
Yes. Okay, we can then move on to the other documents you need to be preparing. That's the next slide.
So now we have the communication. What you need to have in mind is that you are the one, the management is the one who manages the communication. It's not because you need to provide the information to your Works Council first that you cannot talk to your employee, and you must talk to your employee. It's very important that you control the communication, and it's not something that can be left to the employees, to the Works Council. So what do we do in practice? What we recommend is to just after either meeting 0, when we just give the documents, or after meeting 1, is scheduling a town hall during which the management will explain to the employees the main the main items of the project, what you want to do, what is the calendar, what are the next steps, and also the fact that the main objective of the company is to redeploy all the employees within the company or within the group, and that, of course, if it's not possible, that the company will put all its means to support the employees on an external repositioning. But it's very important to manage this part. It's so what we recommend is organizing this town hall for all the employees, but also to draft and to prepare Q&A for employees and managers is very important. You also have in some specific situation letters to prepare for example, the mayor of the city. If you contemplate to close a site or something like this, you will have to send some specific letters of communication to stakeholders. What we highly recommend is really to communicate at the beginning of the process, but also during all the phase of the process. During the information and consultation of the workers, it's highly recommended to maybe each 1 or 2 meetings to send a quick memo to the employees explaining what has been discussed, where we are, and once again, what are the next steps. One red flag, maybe the expert, Fadi?
Yes, yeah, I was just going to say, if you don't do the communication, then the unions will do it for you. And you might not like, well, what they say might not be entirely accurate. And you might not like how they present things to the employees. So you need to be there on the grounds, telling your story and giving them as fulsome information as possible. You also have to be very careful with the experts. The expert is not the enemy. So just to give you a background, the expert, as I explained during the timeline, on the timeline slide, it's someone, an external advisor to the Works Council, whose job is to help them understand the content of the project. There are two types of experts, roughly speaking. One is an external accountant, and the other one is about health and safety. The one we're having the most difficulties with is the one about the accountant, because they will want to understand the project, and of course we're having a difficult relationship with some and better relationship with some others. They will draw up a report which will be presented 15 days before the end of the consultation phase. You might not like what's in there. If you don't, then you need to say so. You need to say so. You need to answer the expert report. HR professionals know that sometimes they are biased, but then the courts might not be as aware as you are, and employees might not be aware of that. So you need to be answering the expert report and draw up an answer to what they say and correct any inaccuracies you have. You can spot in their report. Also, during the process, they will have the right to request documents to the management. They have the same power as the external statutory auditor. They can request documents that sit within the group, that sit within the mother entity. They can request the minutes of the board of the worldwide company over there. So that's something you need to be taken into consideration. So first of all, any document you refer to in your communication in your book 2, they will ask for. What the first thing they do is they ask someone at the company, at the firm, to check any document that's been cited in the documents you provide, and to request these documents to check what we say about that. So of course, if you don't want to be giving the document, then you shouldn't be referring to the document in your communication. That's a litigious point, because if they are unhappy with the content of what you're providing, then the Works Council can request an injunction from the Labor Authority requesting you to provide more information. And that is, of course, a litigious point, because it can lead to the plan not being approved. So that's something that needs to be anticipated, and the relationship with the expert needs to be preserved so that you can get your approval eventually.
And it's important to try to have smooth exchanges with the experts. We can make them sign NDA, so it's something they do not like, but it's possible. What we obtain with Fadi in a plan is that they provide us a draft report before the presentation, before the Works Council, which enables the management to say this information is highly confidential, so we do not want you to put it in the report. It's something that can be done, but you need to discuss with the expert. So you can have some information not in the report. It's something possible to obtain. You can also what we also obtain is with an expert is we sign an agreement with the unions with the content of what they would obtain in the framework of the consultation and the expertise. And that's something that has been approved. So we have things to support you on this expertise, but of course, what said Fadi is very important. Is each information contained in this document can be requested by the expert. So it's very important to just focus on the information you are okay to disclose if they request this kind of documents. Maybe we can go to the next slide. Regarding the recent focus of attention, so it's maybe what we observe over the 2 past years. The main questions we have from the labor administration and the main issue we have to deal with on each restructuring plan. We can maybe go to the next slides. Thank you.
So, as Stéphanie said, this is probably the most important slide of our webinar. Do keep it, and that's kind of your checklist about the recent point of focus that we're getting. We're not going to be able to discuss any and all of this items on the checklist. Some are quite technical, some are quite very specific. So maybe we'll take a few examples. One of them is about the first box over there on the top right, on the top left, sorry, the social and economic committee consultation, the works council consultation on the strategic orientations of the company and the group. So this is something that has been important. The question has been open as to whether you can issue a restructuring plan without having consulted on the strategic orientation. You have an obligation to consult on the orientations every year, training an agreement that says otherwise. Most of the time it's every year. And then if you don't, then there's a question as to whether you can do restructuring. So our recommendation is to consult on the orientations before you start the restructuring plan, if you have the time to do so.
And you do not have to disclose, because once you have done this, what I request is that, but you didn't talk about this plan when you made your strategic orientation, but it's not the same purpose, you know. One is the trends for the next 3 years, and the restructuring plan is a specific project. So you do not have to make a a link between these two consultations, but they can try, your works council can try to make a link between these two consultations.
Yeah. Then maybe another one that we can talk about is the one on the bottom right. It's the one about social selection criteria. So that's of course a hot topic, because when you do a redundancy plan, you don't target persons, you target positions, and then determine who is going to be made redundant in professional categories that regroup employees that can do each other's job with a minimal training from 3 to 6 months training. So it's quite large. Huh? It's larger, of course, than just job positions, and you have social selection criteria based on age, disability, on length of service, professional skills, etc., with a point system to determine who's going to be made redundant, the one who has the least points. One thing that will be important is to be able to define those professional categories. That's a litigious point. We have it in every plan. We have the discussion all the time with the labor administration regarding the categories. And so that will be an open topic for you. And that's something you need to prepare in advance. To be able to cut in slices of professional categories your workforce and to be able to show that they make sense. So first of all, you need to be able to harmonize job titles. Maybe you want a table of correspondences between job titles from, you know, when you have a history of a recent merger,
yeah.
For instance. You want to be able to harmonize job titles and say, okay, these are 2 job titles, but in fact it's the same job. So we're going to have a corresponding table to tell you which job it is, and then you'll be able to split the workforce into professional categories. You also want to have job descriptions. It's a question we get all the time. You know, when we start a restructuring plan, we ask the clients, do you have job descriptions for everyone? And the answer is often no, which is a problem, because the labor authority will be asking for the job descriptions to be able to check whether the slices of professional categories you've made are consistent with their expectation. They want to understand what people do, which is sometimes a bit difficult, let's be honest. So if you're looking at implementing a plan on the long term, let's say in 6 months from today, maybe your first item now would be to use a few weeks you have now to update job descriptions and make sure everyone has a job description. That will be a big time saver for the restructuring plan.
And maybe for the companies that wants to implement a plan in 2 months and they do not have the time to prepare a beautiful job description, what you can do is maybe in this table of correspondence you will prepare having 2 columns. In the first one, you explain the diploma the people need to hold a position in this professional category. And the second one is what they do, but not what are the skills and what do the people on this position. And that will help the labor administration to understand why you decided to split some job position in different professional categories. It's very important to prepare this table. It's the minimum in order to obtain the approval of your plan. Maybe another red flag is if your companies belong to a group with many companies in EU, it's very important that you check before if you need to inform and or consult your EWC. We had this issue in many plans. It's usually in plans when it concerns several countries in Europe. But of course, if your plan is only focused on France, you will not have to inform and or consult your EWC. But just check this point before, because sometimes we had we have bad news, and the labor administration will have to check. If there is this question, they will have to check if you had to consult the EWC, and they will think with their French mind and consider that you have to do it before launching anything in France. So be careful on this topic. That's the first one. And maybe the second one is that what loves the administration is when you provide specific measures for vulnerable population, for seniors, for example, or for disabled. What we usually recommend is to provide for them a longer redeployment leave, 3 or 5 months on top of the other, to have additional compensation, financial compensation, these kind of things. And maybe regarding on the left, in the middle, you see a topic called elaboration of the socio-professional diagnosis. That's something, that's a table which is requested by the labor administration. The purpose of this table is to show if you have some position of some person, and it will be very difficult for this person to be redeployed either within the company, in the group, or either external. So what I request to you to include in this table is, for example, their marital status, if they are alone or if they have a family, their degree, their diploma obtained, family charge, number of training courses attended over the past 3 years. It's something very important also. You need to train your employee, and this kind of information must be reported in this table. And you must also mention the special situation. In 95% of the restructuring plan we have in the firm, this table is requested by the labor administration, so it's something you can prepare during the preparation phase.
So unfortunately, we won't be able to talk about all these topics. If you do have a question regarding this, please feel free to send us an email. We'll be happy to explain on the other boxes. So we'll, in the interest of time, we'll be turning to the next topic, which is the other tools that need to be considered instead of a forced redundancy plan.
So we have additional tools that we can implement. So maybe the most famous one over the few past years is the collective termination agreement. Why? Because in this scheme, you do not have to provide for economic grounds. It's a restructuring plan you can implement, and all the departures will be made on a voluntary basis. So that's the new one. You also have the what we call the accord de performance collective. It's a specific agreement that will enable the company, for example, to modify the remuneration of the employee, you will be able to modify, for example, the location of employees. It's something that must be negotiated with your unions. Then you offer the modification to your employees, and if they refuse, you will be able to make them redundant for what we call a cause for grounds. And then you have the voluntary departure plan. So it's quite the same than the first economic redundancies. It's exactly the same procedure. So you need economic grounds, you need the labor administration approval. So all what we saw before is applicable to these specific schemes. The main difference is that you only have the voluntary departure. Maybe some additional information for the accord de performance collective and collective termination agreements. You need an agreement with your unions. If you have some unions within the company, you cannot implement these two schemes
unilaterally.
Exactly. For the first economic redundancies and voluntary departure plan, it's up to you. It's better to have an agreement because the control of the labor administration will be less strict, but you can also decide to implement this scheme unilaterally. Maybe we can go to the next slide.
Yeah, so that's the quiz slide. If you look at the objectives, maybe your objectives are there for your next restructuring plan if you have one coming. So let's say if I say that you're in your situation, let's say you want to preserve the company's image, and which
tools
tool be you using? Yes, which tool would you be using in this situation? You can answer in the chat box. Okay, so in this situation, indeed, you will try to avoid a false redundancy plan, and you will want to implement, let's say, RCC, yes, the collective termination agreements. In this situation, maybe we can do another one on this one.
What about if you have a highly constrained reduction schedule? Which one would you choose? We would choose the first collective redundancies.
Yeah, of course, because the big problem with the RCC is that you need to get agreement from the union and also from employees who want to leave, which might not always be the case. And obviously, for a voluntary departure plan, it's obvious that you need agreement to be able to leave. So post redundancy will be better in the situation of a highly constrained reduction schedule.
For example, implementation of the one on the right on the top. It would be the APC accord performance collective, the one we talked before. If you have clearly established economic reason, you can go through the first redundancies or a voluntary departure plan. If you do not have any time constraints, you can go through the collective termination. So you have first to think about the objective and what are your constraints, and then you choose the tools which is adapted to your objective. So that was the idea of this slide. Then we can go to the next slide. So on this one, the purpose of this slide is not to explain you everything. You have a lot of information on this slide. It's more for you. If you need to think about the reorganization, then you have all the main tools with their pros and cons. So we have already talked about, we have already identified, but it's more for you.
Maybe we can say about the APC that the purpose of the accord de performance collective, the last column, is not to address reduction in workforce. It's to, let's say, challenge, implement a change in the
employees' employment contract.
Yes, in the employment contract.
You know, for example, when you have a lot of mergers, sometimes you have some contracts, you know, it's not harmonized, and maybe you have some variable remuneration compensation, which are in some contracts and not in others. And with this specific APC, what you can do is negotiating an agreement that will modify the bonus clause in employment contracts, and you will offer this modification to the employees. If they accept, it's applicable as such, and if they refuse, then you can terminate their contract
with no litigation risk. There is a reason for termination that cannot be challenged. So if you don't mess up the procedural steps, they cannot challenge the termination, which is a big plus for
Yes.
this one.
Which is maybe difficult is to obtain the signature of the unions.
Yeah.
In this case, you need to give them something in order to sign. And we talk about the tools, the short-term tools to implement reduction quickly, but we have also, maybe we can go to the next slides, please, Yoshibal, thank you. But we also have tools to think in medium and long term. We have, for example, the mobility plan. So in this one, the purpose is not to make employee redundant, it's only to redeploy all the employees within the companies of the groups to which your company belongs. So that's something which works very well. The only thing is that we need to have a group with a certain number of vacant positions in order to have this mobility plan that works. And we also have the other one is it was called before GPEC, now it's GEPP. It's more thinking about the future, what will be the trend and the evolution of the jobs you have within the company, and it's to think about training plans, is to think about social accompanying measures you can implement to support this evolution of the jobs position within this company. What we usually provide in this kind of plan is, for example, you have an employee who wants to try another company, and during his notice period, he will be able to go back to his previous company. You know, he's secured in his new job, and if he does not like it or something like this, then he can return. But if he likes it, then he leaves. And for him, it's a good opportunity to just try something outside his group. So all this kind of thing, we can imagine it in the GEPP, but it's more a long-term vision.
Mm-hmm. So just, before you go straight to the post-redundancy plan, then maybe you want to consider all these tools before.
And then it's more for your information, but that's what that's our feedback over the past year. So we have an increase of gross redundancies after COVID. Of course, and when we make some employees redundant, we have a high risk of litigation, individual litigation before the French Labour Court. RCC, so collective termination agreement, that's a new scheme, and it's something that is sorry, I was reading the question. That's something which is we have a high increase in France, so it's a good point. And that's something we said, if as soon as you have the labor administration that will check your that will be involved in your process, we highly recommend that you reach an agreement with your unions.
Then we have one question. Maybe you want to go to the question, or do you want to? So the question from Joanna: Can you get around collective redundancies 10% threshold? Indeed, the threshold is 10 for large collective dismissals by negotiating mutual agreements with a few individuals first to keep the post redundancies under 10. So that's a very good question. If you look at case law on this, they do tell you that if you're having a mutual termination and you're not replacing the employee, then that should count as one with regards to threshold. So you're not supposed to do that. Now, in practice, we can see it from time to time, of course. This is something you have to, that you need the expertise of the local HR on this, because they will know what will pass with the labor authority, with the works council, and what will not pass. So technically, you're not supposed to. Now, in practice, we see it quite often. Then we have another question from Yusuf. One phase of the restructuring could be contract modification, harmonization of job category or job titles, working with global teams outside of France. What are the steps that we need to consider regarding contract modifications? Yes, as I say, the steps are, we didn't really talk about it, but that will be a modification of the employment contract process indeed. And the steps are quite similar in the sense that they are included in this. So you would include in your project modification of employment contracts. They would count towards the maximum number of redundancies you would implement, so the threshold of 10 we just mentioned. And then at the end of the process, in the implementation phase, you would offer the modification to the employees. They would have 1 month to refuse. If they do refuse, then you would look for a redeployment, and then eventually you may terminate them. If they accept, obviously, then you don't have a problem. That's quite easy, but they are actually in the same process regarding this. In a nutshell, it's quite the same process, yes.
And maybe one thing regarding this, when we talked about the harmonization of job titles, it was more, it's not a modification of the employees' contracts. It's just to make sure that all the employees who are doing exactly the same thing have the same job titles, because it will be easier for the labor administration to understand what are doing these employees and why they have been gathered in the same professional categories. So it's not always a modification of the employment contract. It's more an harmonization.
Yeah, not everything is a change of the employment contract. We know France can be tough, but not that tough. Not everything is a modification of the employment contract. It's something you have to consider on a case-by-case basis. Do we have any other questions? All right, then I guess it's over to you, Yosiba. Thank you very much for your attention.
Thank you.